Welcome everyone to our Beyond the Net series. And I want to introduce Matt Cohen, who's going to be telling you all about IEPs and if your child's appropriate for it. Take it away, Matt.
Hi, thanks for having me tonight. And I'm a big fan of IS Landing and Merlin and Bluebird. So it's great that the program is expanding, and I'm impressed that there is this training program as part of what the organization does. I am the founder of Matt Cohen Associates, which is a law practice in the Chicago area that focuses on representation of children with disabilities in disputes with public and private schools, as well as in working in the area of adult disabilities and addressing the needs of adults who are having difficulty getting appropriate services or accommodations. I'm going to make an assumption today that because of the target group that is served by IS Landing and Merlin and Bluebird, that most of the folks are relatively new to the IEP process. And so this is going to be a very preliminary introduction. But folks can certainly email me or type questions if you have questions at the end. And I'm going to be dealing with the topic that is basically, how do you get services through the school system with an IEP? What do you do to try to ensure that an IEP is as strong as possible? And that's a subject that I've actually written a book about. So if you want to get into it in much more depth, the book that I wrote is called A Guide to Special Education Advocacy, what parents, clinicians, and educators need to know. And you can find that on Amazon if you're interested in doing a deep dive, along with some other excellent books on advocacy. My contact information I shared already, but this is my office phone number, where I'm hardly ever present anymore because of the pandemic, but you can reach us through the office phone line, which is 866-787-9270. And that's my personal email, mdcspedlaw@gmail.com, if you have questions. So before I delve into the IEPs themselves, I want to talk about how do you get into special ed? Well, you get into special ed through an evaluation, and an evaluation can take place based on either the parent requesting an evaluation for special ed, or it can be based on a staff person making a referral for special education. Once there is a referral and a determination that the child may have a disability, then the school is supposed to convene something called a domain meeting for the purpose of deciding what components of an evaluation need to be conducted. And the parents have the right to give feedback, both to ask for additional elements of evaluation to be performed, or to object to particular forms of evaluation, or even particular types of evaluation. Ultimately, the school is required to get the parents' consent to an evaluation before it's conducted. And then once it's agreed upon, the school has 60 school days in which to conduct an evaluation, and then ultimately, based on the evaluation data, to determine whether the child is eligible for special education. And if they're eligible for special education, the federal special education law, the Individuals with Disabilities Education Act, provides that the child has to be assigned a category of disability that they qualify under. There are 13 categories, and that results in a label. Technically, the label is not supposed to drive the services that the child gets. It's just supposed to be the entry point into the special ed system. And then once the child is in the special ed system, their needs are supposed to be based on their Individualized Educational Program, or IEP. So the label is not supposed to drive the IEP. The individual needs are supposed to drive the IEP. But in reality, the labels often do result in the child's services being essentially pigeonholed based on what label they've been given. So although I'm going to be talking about IEPs, I want to start out with just a quick point about the labeling process. First thing to be aware of is that all labels are inherently stigmatizing and lead to assumptions about the child, just as if you're labeled as a Democrat or a Republican. If you're labeled as having intellectual disability or autism, you're going to be perceived very differently within the educational system than if you're identified as having a learning disability or a other health impairment. So the labels do make a difference in terms of people's reactions, and there's tons and tons of research indicating that the labels actually shape perception, rightly or wrongly. And lots of tracking occurs based on label. So kids tend to be served if they have a label that's perceived as a more severe label. They're more likely to be pulled out of regular education. They're more likely to be put in what's called a self-contained class. They may even be more likely to be grouped with other kids with that disability, which sometimes can be a good thing and sometimes can be the worst thing imaginable, in that the grouping of students with similar needs may end up simply to reproduce and intensify the problems the children are having, and really only serves as an administrative convenience for the school, and not an actually effective educational arrangement for the child. So when you're considering the labeling process for your child, it's not that you just get to pick and choose whatever you want, but assuming that there is data that may support a number of different labels, try to find the label that gets your child the most access to services with the least stigma or segregation, unless for some reason you feel segregation is a desirable outcome, but and under some circumstances it may be. But in general, seek the most access to services with the least stigma. And that, there's no mathematical formula for that, but just keep that in mind in the labeling process. Once you have a label, then the fact that you've qualified for special education allows the child to be entitled to, the legal standard is that they're entitled to a free, appropriate public education in the least restrictive environment. We refer to that as the FAPE standard for free, appropriate public education. And the least restrictive environment, we use the acronym LRE, which is not that the child automatically has a right to be in regular education 100% of the time, but that they should be in the least restrictive environment appropriate to meet their needs based on their IEP, the Individualized Educational Program. For many years, until really just about 3 or 4 years ago, the Supreme Court defined what is a free, appropriate public education using a court case, the Rowley case, in which they said that the determination of what's an appropriate education is based on whether the school district complied with the many procedures in the special education law and the development of the IEP, and that the IEP was, quote unquote, reasonably calculated to allow the child to receive some educational benefit. And that word "some" was the $64 million word, because many school districts interpreted some benefit to mean any benefit. In other words, if the child made a little bit of progress, that was still benefit and therefore satisfied the Rowley standard according to those schools. Many of those of us in the advocacy community think that was a misinterpretation of the Rowley standard, and we argued all along that the appropriate understanding of the Rowley requirement was that the child was entitled to receive meaningful benefit, not the most, not the best, but at least enough benefit to provide value to the student, not just something that was measurable in relation to zero progress. So the question under the old Rowley standard was, is the child receiving some benefit or making some progress? And much of the dispute in special education has been about how much progress is the appropriate amount of progress for the child to receive. But because many people were dissatisfied with the idea that the school could justify itself just based on a limited amount of progress, there was lots of litigation over this issue. And in 2017, the US Supreme Court, in the Andrew F. versus Douglas County School District case out of Colorado, indicated that there's a new standard that should be used in determining whether a child's entitled to a free, appropriate public education. The court required that the school provide an ambitious program that is reasonably calculated to allow the child to achieve challenging goals based on their individual circumstances. That is, that it's challenging for them. Now, the courts are going to spend the next 20 years fighting about what does this mean? And indeed, we're still learning what it means. But my personal view is that the use of the word challenging is very important. And the use of the word ambitious is very important. Ambitious conveys something more than just a mediocre or low-level program that is a minimal program. It conveys a program that has substance and provides a robust level of service. But more importantly, the idea of challenging goals, we can understand challenging to mean something that is capable of being accomplished, but is at the outer extreme of what a person is capable of doing. To be challenging, it can't be easy. It has to be hard for them. It has to be challenging for them. So goals that allow a child to make progress that's just at a low level because we know that they can accomplish it are not challenging. Goals that we think may or may not be achievable, those are challenging. And so this allows us to set higher standards and expectations for what the goal should be. And in concert with that, because the program is supposed to be an ambitious program, the program should match up with the goals in a way that will make it reasonably likely that the child can accomplish the goals. What does this mean? Historically, in the special ed world, the cliche was that the child is only entitled to a Chevy versus a Cadillac. Well, that was kind of a deceptive way to view things, because the assumption was that the Chevy is the kind of inferior level of service, and that you're not entitled to ask for the best or the most expensive level of service. Well, that's clearly, the Supreme Court most definitely said that you can't ask for the best, but they also made clear that the school is not able to just offer a lemon that doesn't allow the child to meet their goals, whether it's under the old Rowley standard or the new Andrew F. standard. And I would argue that what the school should be providing is a vehicle for the child that allows them to get where you're reasonably trying to get them to go, assuming that that goal is a reasonable goal, that gives them a car with wheels, with a working engine, with a safe body, and with enough gas to get there. In other words, that the IEP has to be constructed in a way that has a reasonable chance of achieving a reasonable and meaningful result for the child. So that's a very important change that resulted from this Supreme Court standard. One takeaway from tonight's discussion, if nothing else, when you think about and talk about your child's needs, and you talk about what you're trying to accomplish in the child's IEP, focus on what's needed, focus on what's necessary, focus on what's required. There may be things that could be helpful, that may be optimal, that might be desirable. It would be terrific if the computer that's provided actually has a printer that can do 3D printing, but your child doesn't need 3D printing. So that might be a request, but it's not something that's necessary. But your child does need a computer that allows for doing text to speech and speech to text in order that they can have an accommodation that relieves their difficulty with written material. That's a necessity, and you want to say it's a necessity and describe it and push for it. The things that are optional, great, you can ask, but don't have the same expectation and don't use the same language to talk about them. When a child is made eligible for special education, a whole host of rights attach as a result that are not available to kids in regular education. Parents have the right to be given to provide written informed consent to the child being placed in special ed. And by the way, if your child's in special ed and you really don't like what's happening, you have the right to withdraw consent for special education and to have them return to regular education. That's obviously a risky move to make, but at least there is that right available. The parents have the right to participate in all formal eligibility and IEP meetings about their child. They have the right to receive regular progress reports about how their child is doing and meeting their needs. They have the right to receive notice. This is very important before any decision is made to change or terminate the child's placement or services. And they have the right to request mediation or a due process hearing if the parents are unable to resolve the dispute with the school informally. And importantly, in the event that there is a dispute with the school and you request mediation or due process, then there is something called the stay put placement rule, which provides that the school cannot change the child's placement while the dispute is pending through mediation or due process. That means if your child's somewhere that you like and the school is proposing to move your child somewhere that you don't like, the school has to continue the placement in that preferred program while you try to work it out with the school. Conversely, though, the stay put placement rule also means that if you're trying to get your child into a program that you think is better and you request a due process hearing or mediation, the child stays in the undesirable program as long as that procedure is pending. So the stay put placement rule is generally a very big help for families, but not always, but an important procedural rule relating to special ed one way or the other. Examples of procedural steps that can get schools into trouble. They change a child's IEP and have an IEP meeting without notice to the parent to give them the opportunity to attend the meeting, or they convene the meeting at a time that the parents have stated they couldn't attend. It's a flagrant violation if the school decides what the child's placement should be before they have the IEP meeting, or if they have a meeting and refuse to allow the parent to talk at the meeting, or they change the IEP rather without a meeting. But be aware that there can be informal changes to the IEP as long as the school reaches out to the parent, actually discusses the informal change and gets their agreement. Then they're allowed to document that and modify the IEP without a meeting. But absent mutual agreement, there can't be a change in the IEP without an IEP meeting. However, if they have an IEP meeting, parents are given appropriate notice and they're there, and the school recommends something that the parents don't like, the school is entitled to make that change after 10 days if the parent has not requested mediation or a due process hearing during that 10-day period. Many parents have the mistaken belief that as long as they say they disagree or refuse to sign the IEP, that means the school cannot implement the IEP. That's not correct. The only time that the parent's refusal of signature for an IEP prevents the school from acting is the very first IEP. But once the child has an IEP, if the school district proposes to change the IEP, the parent has 10 days to request mediation or due process. If they don't, then the school is allowed to make the change, even if the parent has strenuously disagreed with whatever the proposed change is. Then we get to the issue of writing goals. Many people think that writing goals is a hassle, including, sadly, many educators. And they see the goals as being kind of an exercise in busy work. Nobody pays attention to them. Nobody uses them. They're written in a level of generality that they don't really mean anything. And sadly, oftentimes that is true of how the goals have been written, but it misses the point. One of the important and beautiful things about the special ed law is that the goals are developed to meet the individual needs of the child based on, and now especially based on the new Supreme Court decision, having challenging goals that we think might not be easy for the child to accomplish, but they should be able to accomplish in a year if given appropriate support. That doesn't mean that they're a contractual obligation that the child will automatically and necessarily meet the goal. And it doesn't mean that the school has necessarily done something wrong if they don't meet the goal, precisely because we want them to be challenging. And we need to be sure that the right services have been provided to allow the child to have a reasonable chance to meeting them. So you want to seek goals in all areas of significant need, but you also want to be careful to not overwhelm your child or the staff with having an unrealistic number of goals, too many goals, too complicated goals. I once had a due process case involving a child who had 93 different goals, and there was no way that the staff could ever keep track of all of those goals, and there was no way that the child could ever accomplish all 93 goals. So try to keep them within reason, though be aware that sometimes schools also say, we have a school rule that we'll only write 5 goals or 6 goals or whatever it is. And that's not right either. There's no maximum number of goals that's legally provided for in the law. You can write the goals that are necessary to meet the child's needs based on what everyone agrees are the priorities. Be relevant. Do you want them to address all of the problems? Are these problems really significant? And will there be time to address the goals that are identified? So don't saddle the child in the school with so many goals that they can't do them, and don't set up goals that don't seem important. For example, a goal that a child will stand on one foot for 10 seconds. Well, maybe that will help them with balance, but after mastering that goal of being able to stand on one foot for 10 seconds, do they have a skill that they need in order to be able to walk or to be able to participate in school? If not, maybe that's not the most useful goal, and there should be a different motor goal that will be more relevant to them. Be strategic. What are you trying to achieve overall? Are you wanting the child to make as much progress as possible? Maybe if your child's in a facility or a program that you want to get them out of, you want to write goals that are relatively easier to accomplish to make sure that they show success in relation to meeting the goals. And maybe conversely, if they're in a program where you want them to get more intensive services, you want to write a very hard goal to be able to establish that they're not making adequate progress and to justify why they need more intensive or involved services. Are the goals measurable? The law specifically requires that there be baseline or present levels of academic performance and functional performance, and then that the goals establish how much progress will be made in relation to baseline over the course of the year, and when measured by the ability to accomplish the short-term objectives or benchmarks that the school has set, which are the stepping stones to accomplish the overall goal. So if the school has a baseline that says that the child has trouble reading, then saying that the child will be able to read at the third grade level as the goal isn't really helpful, because we don't know if they're starting from the kindergarten level, the first grade level, the second grade level. So in order to decide whether the goal is realistic, we have to know how that goal compares to the child's functioning at the beginning of the year. And we want to make sure that the criteria for measurement are the same. So if the goal says that the child will increase their vocabulary by 100 words, measured by the specific type of vocabulary book, test rather, it's not going to be helpful to say that the child knew 50 words the prior year, but using a different set of words than are going to be tested this year. You want to make sure that the method that's being used to assess the child's progress has the same type of data as the method that was used to come up with the present level or baseline. Do you want to do their job for them? What that means is that the school will ask you for input. They're legally required to get your input, but they're the experts, and you want to come prepared to identify what your needs and concerns are, but you also want to make sure that they're providing you with their expertise and their assessment of what the child can accomplish, so that you can hold them accountable to the things that they perceive to be appropriate goals. And then to be more strategic, do the goals embed the placement that you want? So for example, let's say that you want your child more included in regular ed rather than in pull-out or self-contained situations. And there may not be agreement between you and the school as to how much time your child should spend in regular ed, if any. So maybe there needs to be a goal. You want your kid to be more involved with peers in regular ed. So you want to write a goal that says, given the opportunity for social communication with typically developing peers in the regular classroom, the child will engage in reciprocal communication or 3 steps of reciprocal communication by the end of the year. Well, what's important about the way that was written is it can only happen when given the opportunity for interaction with typically developing peers. So by virtue of building that condition into the goal, you make it more likely that the child has to actually be educated, at least for part of the day, in regular education, or they wouldn't be able to have any chance to accomplish the goal. You might also say, for example, you're trying to develop a situation where the child gets more adult support. Maybe even they need a one-to-one aid. And so you say, given initially 3 prompts to be faded to 1 prompt within X amount of time, the child will be able to carry out X, Y, or Z task. Well, in order to have that goal implemented, they need to have an adult there to give them a prompt. So again, by the way that you've written the goal, you've to some extent influenced the extent to which the child's in regular or pull out, and the extent to which they get support from adults rather than having to just function on their own. The law requires that the school district carry out in the IEP very specific details about how the IEP is going to be implemented. So there's a requirement that the IEP has to be in place at the beginning of the year or at the beginning of the next academic semester. If the IEP is being developed in the fall, it has to be ready to go no later than the start of the spring semester. And it has to be very specific. It's supposed to list the number of minutes, or at least a range of minutes that are going to be provided. And it's supposed to list the starting date, frequency, duration, and location of services. Say that again. The initiation date, the frequency, duration, and location of services. That means, is it going to happen once a week, 3 times a week, 5 days a week? Is it going to happen for 20 minutes, 40 minutes, 60 minutes? And is it going to happen in the child's regular ed classroom, in a pull-out classroom, in a therapist's office, or even in the lunchroom? Starting date, frequency, duration, and location of services are supposed to be specified. It's better to list by the week rather than the month. Schools oftentimes try to list by the month so they have more flexibility about whether they provide all of the services on a regular basis or not. But you want to try to spell out it's going to be provided X number of minutes a week. Or if it's a month, make sure that the X number of minutes a month, when you divide it up, provide for enough services that your child's needs are actually being addressed. Spell out, is the service going to be an individual service or a group service? Is it going to be provided on a push-in or pull-out that basis? That means, is the teacher or staff member going to come into the regular class or pull the child out of the class into some other setting? Anything that isn't specified is at the direct discretion of the teacher or related service provider. And there are some reasons that schools might want to do group versus individual. For example, if a child is a child with a social communication problem, having a group where they can practice their communication with other kids might be useful. But it's also the case that if they have 5 kids in a group and that's all they're doing, that means that they're using their staff person for 1 hour to serve 5 kids. Whereas if they had each child getting an hour of individual therapy, that would be costing the school 5 hours of service. So while it has some utility for the child as a strategy for how to help them, it may also have a hidden motivation, which is really more efficiency and to save the school district time and money by grouping the services together. Same thing with respect to push-in versus pull-out. If a teacher is pushing into the classroom, they may be able to work with 5 or 10 kids at one time, whereas if it's pull-out, the number of kids that they're serving may be smaller. So these things may have utility for the child, but they may also be driven by administrative considerations that have no value for the child. And you should have a discussion with the school about why they're doing individual versus group, why they're doing push-in versus pull-out, and make sure that the model that they're using is actually the model that makes sense for your child. Accommodations are supposed to be listed in the IEP. Accommodations are different than instruction or therapy. They're things that are going to be provided to assist the child in being able to navigate and function at school. Things like that they're going to be given preferential seating at the start of at the front of the class so that they can see better or hear better, or that the teacher is going to check in with them to make sure that they understood the directions before they're expected to carry out the task, or that they're going to be given extra time on tests in order to be sure that they're able to finish the task in a way that fits with their performance style, and that what you're measuring is their knowledge of the material instead of just how quickly they can work. And so there are things that sometimes are written when you get to the accommodations section of the IEP that seem like they're reasonable because they're trying to build in flexibility, but they may also build in so much flexibility that in fact the accommodation isn't done. So for example, if you have an accommodation that says that the child may request the ability to test in a quiet room, but the child is self-conscious about testing in a quiet room, they're never going to ask. And so having the accommodation written as on student request is actually a way of guaranteeing that the accommodation isn't going to happen. So if you're concerned that your child isn't going to request the accommodation, then you don't want the accommodation to be written that way. Similarly, if the accommodation says at teacher discretion as needed, well, maybe the teacher will decide that it's needed, but if it says as needed and you think it's actually needed, not as needed, then you want it to say the accommodation must be provided, not that it's discretionary. So these sorts of qualifying terms can make a big difference in terms of whether the things that you think your child is getting are actually going to be provided or not. And one important additional broader comment to make is many people have discussion with the staff or at the IEP meeting with the staff, informally or at the IEP meeting, whether they're told, well, we'll take care of this, don't worry about it, we're going to do it. If it's not written down in the IEP, it's not legally binding on the school. So you want to make sure that anything that they're agreeing to do gets written down in the IEP. And one of the things that I will mention to a school staff, they say, well, we've got great teachers, they always do this. I said, well, that's great. But if those great teachers retire and a new teacher is hired who isn't used to doing it, we want to have something documented in the plan to make sure it's going to happen. So remember, if it wasn't written down, it may not be as likely to happen. Also be aware, this is very important, accommodations are workarounds. Accommodations don't teach skills by themselves. So for example, if you have an accommodation that says the teacher will check the assignment book for accuracy, you should have a parallel goal that says the student will record their assignments accurately. It shouldn't have to be a trade-off where either the child gets the accommodation or there's a goal. Oftentimes there's an argument for there being both an accommodation and a goal. Similarly, let's say that the child has a problem with writing, and so they need to use a keyboard or a word processor. So the accommodation says may use word processor for essays, but the child hasn't been taught how to type. So you need to have the accommodation that says they'll use the word processor, but you also have to have a goal that says they'll be able to type X number of words per minute with X degree of accuracy in order to ensure that they're not just provided with the technology, but they're actually able to use it for the intended purpose. Otherwise, the accommodation isn't really effective or helping them. What about kids who are having behavioral problems? This is a topic that I do hours of training on by itself, but there are many protections built in for kids with behavioral issues within the special ed system and that are treated differently than kids in regular education. And they include that if a child is having behavioral difficulties, well, overall, think about a child who is at risk of having or having behavioral difficulties as needing to construct a behavioral umbrella to protect the student so that they're able to function well and not get into trouble. And so the first thing that you have to be concerned about is that if a child is getting into behavioral difficulty, they're subject to suspension or expulsion. Suspension is allowed for up to 10 school days in the aggregate in a school year. Expulsion is allowed if a child is demonstrating behavior that warrants expulsion that is not a direct and substantial relation, substantially caused by their disability. So you want to build in things that identify what are the things that might cause a child to have a behavior problem, like that they don't understand right from wrong, or they have trouble understanding oral directions, or they have ADHD and they have an impulse control problem. So it may be hard for them to avoid blurting out in class or saying things that are inappropriate, or they have a tic disorder and they may say stuff that's improper or problematic, but it's not because they can control it. It's happening because they can't control it. So you want to build those sorts of things into the IEP so that if a problem comes up, it's already identified that there's a behavioral issue related to their disability that's likely contributing to the problem. It's things like as I mentioned, that the child lacks cognitive ability, they have a processing delay, they may have a sensory regulation problem or difficulty controlling impulses. The other thing that you may want to look at is that the school district is supposed to, if a child has an anticipated or is having behavioral problems, is that the school should be identifying and developing a set of strategies for how to manage the behavioral problems. And in particular, there's a procedure called a functional behavioral analysis, which involves the school studying the child's behavior and attempting to identify what are the things that are causing or triggering the behavioral problem in order to figure out what can be done to change the child's environment in order to reduce the things that are triggering the behavior, and to teach the child, if there are skill deficits that they have, to help them to learn what are the more appropriate behaviors, or to find ways to address whatever their behavioral need is in a more appropriate and adaptive way. The underlying premise of this is that all behavior happens for a reason, and if we can identify what the causes of the behavior are, we may be able to, again, both modify the environment or address the things that are triggering the behavior to give the child a way to behave differently or to reduce the chances of the behavior happening. And then we want to develop strategies that identify things like planned ignoring, redirection to task, providing access to a trusted adult, or giving the child a chance for a quiet time to regroup, restorative opportunities to work out problems, access to counseling. These things are all good for students, and here's the additional payoff, if the school has things like this listed in the IEP and they didn't carry them out, then that's an additional basis for the school to be prevented from suspending or expelling the child unduly, because they're legally required to carry out the things that were in the behavior plan, or they're not supposed to exclude the child from participation in their existing educational program. All right. Overall, if the child is not making meaningful progress from the parent's perspective, you want to be going back to the school and making it known to them that you're concerned about the child's lack of progress, and ask them for assistance in beefing up the IEP and providing more services and supports. Conversely, if the school is saying the child's not making appropriate progress and they're getting ready to move the child to a setting that the parent doesn't want, you want to try to make sure that they actually have adequate data to support the fact that the child's making progress, and that they've been providing all of the things that can be offered to support the student within the less restrictive setting. So remember earlier I mentioned the idea of least restrictive environment. You're not supposed to move a child to a more restrictive environment unless you either have data that supports that all possible interventions in the less restrictive environment have been tried and failed, or that there's professional reason to believe that the possibility of more support in the less restrictive environment wouldn't be successful. But both from the standpoint of what the school might argue and from what the parent might argue, data becomes a very important part of the discussion of what to do with a child who's having difficulty. Does the data support the change? Does the data support more aggressive intervention within the existing program? Or does the data actually indicate that the child's just doing okay and that a change isn't warranted? So what do you do in order to deal with data? You have to be charting the data. You have to look at all of the different sources of data. And indeed, within the school setting, there are lots and lots of different sources of data, including what the diagnoses are, both educational and clinical, the test scores that have been obtained from either individualized testing or school-wide testing, grades, which are highly subjective, but nonetheless a source of data, the teacher comments on the report cards. Oftentimes, I can do all sorts of things with the little comment sections where teachers said, well, Johnny's doing fine overall, but he always blurts out answers and is constantly talking to his peers and showing impulsive behavior. Well, the schools failed to identify the child as having attention deficit hyperactivity disorder. Their grades are fine, but when we looked at the teacher comments, it turned out that they were regularly documenting the fact that Johnny was having these problems. What are the school and the parent identifying as areas of need? What are the present levels of performance being listed on existing IEP documents? What growth or change are they making in goal statements? If the goals continue to be the same goals year after year, you have to ask yourself, well, since the goals are not changing, does that indicate that there's been a lack of progress? Have the service minutes been increasing or decreasing? Is there any concern about whether the minutes of service on the IEP were actually delivered? Because if the school didn't implement the services that the child was supposed to be getting, then they shouldn't be considering moving the child to a different setting or more restrictive setting when they failed to provide the things they were supposed to provide in the existing setting. What are the frequency of detentions and suspensions? What behavioral data is there to confirm either that the child is having behavioral problems or doing well in terms of behavioral functioning? What's the history of communication between the parents and school? Has the parent been provided with the documentation of progress or lack of progress, which, by the way, is supposed to happen at least quarterly and as often as informal reporting is given to parents in regular ed. And by the way, it's often useful to ask the school to provide all of the email communication, both between the school and the parent and among the school staff, because frequently there will be information about how the child is doing in the email that wasn't provided in the formal reports. So all of this data becomes useful. And for those parents whose kids are already in special ed, be aware that this past year was unprecedented because everyone was in remote. And that was really the first time that the parents often had more data about how the child was doing educationally than the school had, because the child was being educated at home. So try to accumulate any data that you've had. And if your child's in remote learning now, for whatever reason, keep data on how the child is doing and keep data on what the school has been providing and whether they've actually been delivering the things that they promised. Okay, then some basic IEP principles. Know your child and follow your gut. If things don't seem to be working, check it out. Many parents have kind of a, we're supposed to trust the public school, they're the experts, and so we defer to them. That's certainly appropriate to a degree, and it's appropriate to be respectful of the expertise of the educators, but you also have very important knowledge and experience about your child. And sadly, the school does not always communicate problems when they're happening, and they sometimes don't even recognize problems when they're happening. So if you've got a feeling that something's going on that's problematic, check it out. Promote collaboration and trust as much as possible, but keep track of what's going on and don't take for granted that you're being given the full picture of the situation. If your child's having any sort of difficulty at all, I think it's very wise to go and observe on a as frequently as you can, at least a couple of times a year, and recognize that when you're observing, you're looking for how your child is doing. You're also looking for how your child's being treated, how the other children are being treated, how the classroom is organized, whether they've got the right supports, whether it's noisy or quiet, or whether the teacher is respectful of the kids. So there are many things that you learn about observation that are not just about your child's performance, but about how the educational program is going. Prioritize the things that are most important to your child's success. And related to that, don't sweat the small stuff. In fact, the special ed law is very, very complicated. The IEPs are pretty complicated. And there's hardly an IEP that I've ever read, and I've read literally thousands and thousands and thousands of them, where I couldn't find something about the way that the IEP was written that I could criticize or say was deficient. That doesn't mean that the deficiencies were always important. And importantly, a small story, my son, who's now an adult, had an IEP when he was in preschool. And shockingly, the preschool teacher put the IEPs on the wall of the classroom, which was a gross violation of confidentiality. But she put the IEPs on the classroom wall because she wanted all of the staff to be constantly paying attention to what the child's needs were and referring back to the IEP because she took them very seriously. And it happened she was a wonderful teacher, and she actually used the IEPs as a much more meaningful document than many other teachers did. So even though the posting of the IEP was very bad from a confidentiality standpoint. We decided it did not make sense to complain about that because she was using it in a creative way, and we wanted to support her rather than to set up a problem with her. So our priority was on the quality of the instruction, not on the fact that the IEP was posted on the wall when it shouldn't have been. So don't sweat the small stuff. Make love, not war. Try to build relationships with the school staff. Try to collaborate. Try to talk with them before IEP meetings so you can have an idea going into the IEP meeting of what they're thinking about, and they have an idea of what your concerns are about. And unfortunately, sometimes it's not possible to work things out in a collaborative way, so there's conflict. When there's conflict, then you have legal recourse through both the mediation procedure and the due process procedure that I mentioned earlier. But mediate wherever possible. Due process is a worst case option that should be avoided whenever possible. In our private practice, we mediate 80 to 90% of the cases at the IEP level. And then when we request a due process hearing, we use formal mediation, and we're able to resolve 80 or 90% of those cases with mediation without actually having to go through with the hearing that we requested. So as much as possible, try to work things out with the school and maintain a good relationship, and try to be sensitive to and think about what it's like to be in the teacher's shoes, as well as expecting them to be sensitive to what your child is going through and what it's like to be in your shoes. All right, so it's now 10 of 7. I'm going to stop in order to make sure that folks have a chance to ask questions. I do ask that your questions not be a lengthy story that tells me all about what your child's history has been. And in fact, I don't really, I shouldn't give personal advice in this context. So try to just ask general questions if you have them, and I'll be happy to try to answer them. Lori.
Hi, thank you so much for doing this. My question has to do with reading instruction. I know that there's certain instructional methods like Wilson or Orton-Gillingham, that kind of thing, that are effective for children who struggle to read. And how is it best to, my son is placed he's in his neighborhood school, and they don't have, none of the teachers have training on that, but I know that I both have research articles for his specific condition that's what he needs, a system, a structured literacy multi-sensory program.
So unfortunately, a lot of these situations, there are things that seem obvious, but the school is not required to do them just because they seem obvious. But there is actually a provision in the law that says that schools are required to use research-based practices to the extent practicable, and to select methodologies that are effective. So in order to establish the need for the reading programs such as Wilson, you're going to need to be able to show that the reading programs that are being used are not effective, and that the type of reading problem that your child has is likely to be addressed or remediated by a multisensory program like Wilson. So that's not automatic or common sense, but if you can show that what they're doing is not working, and either through the child's profile and what Wilson addresses, or through the use of a private psychologist or speech pathologist to document that the learning problem is one that lends itself to the research-based practice like Wilson, then there's a basis for arguing it. And if the school doesn't have it available, then that's where they're probably going to say no because they don't have it available. And then that's unfortunately where sometimes people need to get an advocate or a lawyer involved and push the school. And then hopefully if the school looks at the data and realizes that the problem is there and that they're not really addressing it, then they either voluntarily choose to bring in the Wilson trained people themselves, or then you have to go to mediation or due process and force them to do it. And
if it's in the IEP, do they have to, not Wilson, but let's say you have multi-sensory research.
And they got to do it. It's in the IEP. So that's where the starting place is to try to get it into the IEP. But if they don't have it, they're probably going to say no, because not because they disagree with it, whether it's necessary, but because they don't have the service and they don't want to pay for it.
Okay, thank you.
Another question. How do you write an IEP to persuade the district that your child, to place your child in an out-of-district school such as Therapeutic Day School? It's a great question, and it really, the answer is very similar to the answer that I just gave in the prior question, which is it's all about documentation. So what you want to be able to do to support the need for Therapeutic Day School is identify what are the things that are happening in public school that are problematic, that the regular school or special ed program in the regular school has tried that don't seem to be sufficient. What's the level of support that the child needs? What's the level of supervision they need? Are there problems with larger versus smaller classes? Are there specific techniques or interventions that are available in the therapeutic schools that are not available in the public school? What's been tried in the public school? Have we exhausted all of the possible interventions in the public school? So all that's left is the therapeutic school. And then be aware that therapeutic schools, there are hundreds of therapeutic schools in the Chicago area, and they have very different programming and very different needs. So you need to not only just say my child needs therapeutic school, but what type of therapeutic school? And frankly, some of the therapeutic schools are, you wouldn't want your child in them. So you want to make sure that you identified what the child needs and what should be avoided for the child, so you don't end up in effect winning the battle and losing the war because the school district agrees to therapeutic but then places your child in a program that you feel is very inappropriate for your child. Another question. Oh, can we do IEPs for private schools? Private schools are not covered by the special ed law unless it's a state approved private school and the child is placed pursuant to an IEP. But if you place your child on your own at, let's say, a private regular school or parochial school, the only hope you have is that they either take federal money, which would mean they're covered by 504, or if they're not a religious school, then they're governed by the ADA. So, for example, some of the private prep schools like Parker and Latin are governed by the ADA. But the ADA has much less protection than the special ed law does. So we do end up in fights with private schools sometimes because they're not providing appropriate support for a child with a disability. But it's much less easy to advocate with a private school than it is with the public school because the special ed law is so much more detailed in relation to the public school.
Matt, Elizabeth has her hand raised.
Okay.
Hi, thanks, Evie. Thanks, Matt. So I have a child who she goes through, she's, generally like at her baseline, she does pretty well, but she's definitely had periods where, she could go for like a week or even a couple of months where she goes through a really tough time, has some behavioral issues. And so I'm trying to figure out if you're doing, the testing for the IEP, and she's like in her baseline feeling good state. How do you account for those times where she may have like a much tougher time?
Well, that's difficult, but you are supposed to take into account how the child presents when they're doing well and they're doing less well. You may also need to kind of try to schedule the testing to catch it at a time when the child's having more difficulty. But you also may need to develop a program that's designed to address intermittent need. So you don't set up a program that's a rigid program under those circumstances that's going to be the same whether she's doing well or not. You might need to have it be, in effect, flexible to kick in. For example, I don't know what your child's needs are, and I don't really want to know it in this setting, but imagine a child who has bipolar disorder, and there are times when they're very functional, and there are other times when they're very dysfunctional. Well, you don't ignore the fact that they have bipolar disorder just because they happen to be functional at a particular time. You develop a plan that's intended to provide support for when they have more significant difficulty and need the intervention. So it's trickier to get the child identified under the circumstances you're describing, but not impossible. All right, so let's try another one.
Beth.
Oh, did you say Beth, Evie?
Yes, I did. Sorry,
Thank,
Beth.
thank you so much. Hi, Matt. I have a question for you. I think My son is 10 years old, and what the most common question that like comes up when I'm with other parents of children with special needs, and I have friends who are in CPS, private schools and therapeutic schools in the Chicagoland area, is that oftentimes going into an IEP or just in general making decisions about schools, parents feel very like paralyzed by not knowing where is good or where to go or where to request, where to be placed. Do you know of resources, or do you have a resource for parents about what school, about just about different schools, both public and private?
There's no good one-stop place to go.
Right.
And in fact, just to emphasize your point, I had a case a number of years ago where I was having to do a deposition with all of the senior CPS staff. And I asked each CPS staff person to identify which programs they had that would address the different problems that we were bringing up. And every one of them gave different answers. There was no consistency because they didn't all have the same access to information, which is the problem that you're facing. The best I would suggest is that you hit the mommy and daddy grapevine, which I'm sure you're trying to do. You hit the local school councils, you look on the websites. If you've been given a lead to a school, there is an organization called the Family Resource Center on Disabilities, which has information on many schools. There's an organization called Raise Your Hand, which has a very extensive parent network and a great website where you actually Facebook page where parents often post questions about what do you know about this school, or which schools have these programs or whatever. And you ask attorneys and advocates like me and clinicians like the folks at IS Landing. But there's no reliable one place to go. And one of the prior questions raised the question of Wilson reading. That's interesting because CPS has been changing its procedures with respect to Wilson reading. And at the same time they were changing their position on Wilson reading, the person who was in charge of Wilson reading left. And so they have a new administrator. And I share that story to say that I don't think anyone in CPS could tell you coherently all the places in CPS that have Wilson reading right now. It's just there's no consistent knowledge base. And so it's very hard to get those answers. So I would say it's a frustrating answer, but leave no stone unturned, hit every source you can possibly find to get clinical and professional input on what's out there. All right, next question. I think it was, yes, you.
What was me? Thank you.
Oh, yeah.
Go ahead for doing this. And thank you, Bluebird. One thing that really stood out to me is actually on this slide where you said like follow your gut and things like that, and kind of checking how your child is doing, in the classroom setting and how like the teacher's treating them. Could we can actually observe, like we can go into the school, and is that like allowed?
It's not only allowed, it's legally allowed. There's an actual law that says that you have a right to go and observe. It doesn't say how often. It does say it has to be within reason. And they're allowed to say things like, not the first 2 weeks in school when we're just getting organized, and not if there's some problem happening and you have to give advance notice and make an appointment and yada yada. But yes, there's an explicit law that not only gives you the right to do it, it also gives, and there's a question here from Elizabeth about independent clinicians. It allows you, if you have a private clinician, for the clinician to go and observe. So the procedure is you contact the principal, you make a request, and they're supposed to do it. And they're supposed to treat you the way they treat other people. So again, it doesn't mean you can come every day, but they also can't just say no. One of the tricks that you need to be careful about is they'll frequently find the least helpful time for you to come and observe. So you need to convey, I want to be there for the English language arts class or for the math class or wherever it is that there's a problem, or they'll have you watching the PE class, And,
yeah. Okay. So basically a lot what you were saying is kind of like be specific, like when I want, like everything's like in the.
Typically it's going to be an hour or two. It's not going to be full days. It's not going to be repeated days. And if you might get to go in a couple of times a year, but not more often than that. there's,
will help us reflect on our relationship.
Someone needs to mute it, I think. Elizabeth posted a question because it's kind of related. What role can your third-party service provider play? And the answer is very big role. Schools are not bound by what the outside clinicians say, but they are bound to give serious consideration. Again, somebody needs to move. The outside clinicians are entitled to give input, and the school district has to give serious consideration to what the outside clinicians have to say. And in fact, if there's an outside clinician involved and there are concerns about school, really good idea for the outside clinician to go and observe, because they'll have even more credibility if they're not just speaking about what happened in the clinical office, but what they saw in school as well. And then there's a question, if we're choosing to engage an advocate, is it best to start with the advocate or bring them in the IEP if it's not going as we hope? I have families who decide they want to get an advocate involved just because they feel like it's a complicated process and they want some help supporting themselves or understanding what's going on. The reality, rightly or wrongly, is that when you bring anybody who's an advocate or a clinician to schools, the schools may get defensive about that and have a negative reaction to it. So you have to really make a timing decision about, are our concerns great enough that we want to risk kind of increasing the tension level between us and the school, because the likelihood is if you bring an advocate that that's going to happen. But in fact, sometimes having the advocate there can help to solve the problem, because they may not be as emotionally tied up in the situation as you are. And if the school brings their lawyer, their lawyer may not be as emotionally tied up in it too. Sometimes it's helpful to get the advocates involved at the beginning. But I would say, whether it's an advocate or a lawyer, solve problems directly and on your own as much as you can. So better to have a good collaboration with the school and not bring in advocates or lawyers unless you conclude we really need it. But once you decide you need it, then do it. You have a right to it.
I know we've had members of our team go to IEPs or Zoom, do a Zoom meeting for the first one. So I know it's been helpful. I hope it has been.
I think that clinicians are not as threatening as advocates. Advocates are not as threatening as lawyers. And there's a lot of variability in terms of how school teams respond to people who are coming with the parent. But sadly, and I don't mean to be overly negative, but my experience is that in many instances, the orientation is that parents are to be seen and not heard. And so as soon as they start bringing advocates or clinicians, that creates even stronger of a reaction of, we want the parents who are not complaining. And as soon as the parents begin to raise concerns, either on their own or with the clinician or advocate, then some defensiveness happens. And that's, again, that's a trade-off that parents have to assess, but don't shy away from advocating for your kids. If the kids need things, you need to step up, and you have a right to step up. All right. Any other questions? Well, this was good. Appreciate the interest, and hope this was helpful for everybody.
Yes, thank you so much, Matt. And we'll send out your presentation to everybody. And of course, we'll have it on our websites.
All right. Take care.
Thank you so much, everyone, for joining us. Bye, Matt. Everyone have a happy Thanksgiving.